So, Asha, what the heck is Judge Cannon up to in the Mar-a-Lago case?
It's complicated. I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal contributor for ABC News.
And I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And we're here to help you understand topics that can't be boiled down into a soundbite or a tweet. Okay, Judge Cannon definitely cannot be boiled down into a soundbite or a tweet.
Yeah, I don't know what to make of what she's up to. She has no trial date set in this case, doesn't appear to be on a fast track to anywhere, and yet she has enough time to spend 2 days of hearing on an argument that every court has rejected that has considered it thus far, namely whether or not the special counsel regulations are constitutional.
Right. And also, in sort of an extraordinary move, she allowed Amici to come and argue it.
Yeah, because she thought this was worth 2 full days of argument. I mean,
that doesn't really happen at the district court level, does it?
No.
Where like rando parties come in and get to argue a legal issue that when they're not parties to the case?
Very, very unusual. It really occurs in circumstances, usually in the criminal context, it occurs in circumstances where the Justice Department, let's say there's a change in administration, takes a position on appeal where they abandon effectively the position that was taken that resulted in the conviction. And so essentially the court has to appoint someone to represent that position. But in the district court, don't really see that at all. Rarely see amici filing. When they do, they can, their views are sometimes considered by the judge, but they usually don't have any oral role. Okay, they're not there arguing. And I will say I can't remember the last time that I saw this long taken on just purely legal arguments on a purely legal issue. I defended the constitutionality of statutes that I was charging for the first time when I was a federal prosecutor with no oral argument whatsoever. So I don't know what to make of this, but given that these regulations have been challenged before, Asha, by Manafort and also by that Russian company that had the expensive lawyers hired that were bringing all sorts of challenges in court, and in both circumstances, the courts upheld the constitutionality of those regulations.
Yeah. So maybe we should do a little Wayne's World, back in time, just to get our listeners up to speed. Because this is a little bit in the weeds kind of legal argument, right? You kind of have to start with the previous framework, the independent counsel statute. I just think that that's some helpful background, which had a whole different appointment structure. Basically, it was legislation, and the legislation,
it empowered judges.
It empowered judges to select an independent counsel, basically.
Right. I believe a D.C. Circuit judge who ultimately appointed Kenneth Starr, if I recall correctly. It was not anyone associated with Janet Reno or her Justice Department that picked him.
Yeah, and the constitutionality of that was challenged on separation of powers grounds because, this was basically effectively through the legislation. The argument was Congress was creating a prosecutor, like it was taking on an enforcement function is what people argued, and which was beyond Congress's power. And this issue went to the Supreme Court, and in a narrow 5-4 opinion, it was upheld.
Yes, in an opinion that would not pass muster before the Supreme Court of today. There is, I think, if I recall correctly, wasn't there a dissenting opinion by Justice Scalia that a lot of conservatives really latched onto, and I think would be the majority opinion in today's Supreme Court.
That's right. In that case, Morrison v. Olson, I believe the reasoning has been questioned in subsequent cases. I'm not exactly sure what the specific issues raised, but in other words, it's a little bit even dicey beyond Scalia's opinion. So the Morrison reasoning, though, has a piece which I think comes to bear even in this new framework, which gets to the appointments clause. And I'm going to let you unpack that because I know that you were in the weeds on that. But just so people understand, the independent counsel statute expired in 1999. And then in its place, we got the special counsel regulations. And the special counsel regulations are promulgated from within the executive branch. And that, it empowers, it's promulgated by the Department of Justice and empowers the Attorney General to appoint a special counsel. So in terms of that separation of powers issue, that piece seems to have been resolved by kind of bringing this whole framework squarely within the executive branch. But we still have this other appointments clause problem, which you can explain.
That's right. So the appointments clause of the Constitution says that the president, by and with the advice and consent of the Senate, shall appoint all other officers of the United States. So there's a bunch of things that, counsels and public ministers and judges of the Supreme Court, but also all other officers of the United States whose appointments are not herein otherwise provided for and shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of departments. The idea being that heads of departments, that was really, I think, what the framers were thinking about at that time. Let's just say the Secretary of State, for example, would need to be appointed with the advice and consent of the Senate, but inferior officers of the State Department, for example, could be appointed by by the Secretary of State or by the President if Congress essentially vested authority in them.
Right. And am I mistaken that in Morrison, they also addressed this particular issue in the context of Congress, authorizing judges to select someone?
That's right. It's not obviously an issue here, unless, in this case, because here you have essentially a special counsel acting as a subordinate to the Attorney General, reporting to the Attorney General. However, and this is something you and I discussed a little bit, one thing that is interesting is that the special counsel regulations, which were crafted after the whole Clinton impeachment, I think when both parties realized that maybe special counsels had, independent counsels had run amok. They didn't want to have a truly independent counsel anymore. It talks about essentially the special counsel serving the role of a United States attorney. And United States attorneys are officers, just like, for example, the deputy attorney general or an assistant attorney general, who is appointed with the advice and consent of the Senate. And so it's interesting because one thing you and I were discussing is how independent is the special counsel? How much supervision is Merrick Garland really conducting of the special counsel? And I think that's really where the argument before Judge Cannon was going as well.
Yeah, and this is why I kept mentioning the background of Morrison, because my understanding is that Trump's lawyers went in and, among the different arguments they were making was this an argument that Morrison v. Olson needs to be overturned, which I don't know if it's necessarily dispositive of this particular issue, but it's at least ancillary to the question which Trump's lawyers are raising that, by the way, is coming from an argument that a conservative legal scholar named Stephen Calabresi made in 2018 with regard to the appointment of special counsel Mueller. He said exactly what you just pointed out, that, when the attorney general is appointing the special counsel, and, the degree of independence that the special counsel has effectively makes him a principal officer. Like, he steps into the shoes of the attorney general, and therefore this, violates the appointment clause. And as you noted, this question was raised by Paul Manafort in his prosecutions, and a Trump-appointed judge, Judge Dabney. No, that was in the Russian case. The Paul Manafort case also upheld Mueller's appointment. Then, when Mueller brought the charges against the 13 Russian nationals and 3 companies that he prosecuted for election interference, they brought up that argument, and that was a Trump-appointed judge, Judge Dabney Friedrich, who also said, no, he's totally kosher.
That's right. I mean, one thing to keep in mind is that the regulations provide that the special counsel will notify the attorney general of any major decisions that they're making, essentially giving the attorney general the opportunity to overrule the special counsel, which would then require reporting to Congress. And there was a lot of questioning based on public reporting by canon of the member of the special counsel's office who was arguing this motion about whether or not Garland was in fact reviewing and they had approved of the indictment in this case and what Garland's specific role was. And the representative from the special counsel was not answering those specific questions. And that really made her unhappy or displeased.
Right. And I think the question is, how much does there need to be actual supervision versus how much is there theoretical supervision? Like, in other words, Merrick Garland, as per the framework, has the ability to, request, he can give more latitude if he wants, but he can also exercise, certain veto power over these prosecutorial decisions that the special counsel makes. I mean, we discussed this a lot during the Mueller investigation of, to what degree did Mueller have to, and it seemed like in the Mueller investigation, Mueller was much more going back and forth with Rod Rosenstein at that time. I assume because he kind of wanted to have every I dotted and T crossed in terms of not going beyond the scope of his mandate. But, even if Merrick Garland has not done that, because I think the question was, did Jack Smith clear this, search warrant through Merrick Garland? Did Merrick Garland actually approve it, or did he, take the step without the supervision?
Yeah, I think one difference between Robert Mueller's mandate and Jack Smith's mandate is that Robert Mueller was tasked with a whole wide variety of things. He was investigating this election interference. He took over the Manafort cases that were already really investigations that were well underway. He investigated a number of other matters that kind of arose from his investigation, various obstruction and false statements and so on. But I think he really needed to clarify at times with Rod Rosenstein whether or not he had the authority to investigate X, Y, or Z. Jack Smith is coming in very late in the game. In fact, things were pretty far along on all of these fronts by the time Jack Smith became involved. And I think it's much more well-defined what his role was.
But this is what it sounds like Judge Cannon is homing in on.
That's right. I think that's correct. I mean, I think there was, and I think one interesting point that was made by her that really showed, I will say, that she was not entirely taking Trump's side here, is that she noted a tension that really both sides had in their argument, right? On the one hand, the special counsel's point is, yes, we are being supervised by Garland, but no, we're not. Garland's not the one making the decisions, essentially. And the reverse was happening essentially with Trump's team, where they were trying to essentially say Garland was making the decisions, and yet he was not at the same time. There was a bit of a tension in that argument that she made a big point of.
Yeah, and I mean, I think we just need to zoom back and, the implications if, the special counsel is considered to be a principal officer would really mean that you wouldn't be able to create a buffer between the attorney general and the special counsel. So the point here, if you look at the regulations, is to really walk this fine line of giving, it seems like they designed it with the idea that it was giving the attorney general just enough supervisory capacity to kind of pass muster under this appointments clause, because obviously one of the main purposes of a special counsel, again, this is an outgrowth of the independent counsel statute coming on the heels of Kenneth Starr, is this is a person who might need to investigate the president. So if it becomes somebody that has to be appointed by the president, you kind of defeat the purpose.
That's right. And I think one thing that is really going on here that's maybe a little bit of a theoretical or philosophical point here is if you have authority to supervise or to overrule someone, but you say from the outset you don't intend to exercise it, and you in fact do not exercise it, are you in fact supervising the person? Do you have supervisory authority? Theoretically, of course, Merrick Garland could be all up in Jack Smith's grill. And could be, demanding frequent updates and ultimately overruling some of Jack Smith's actions. He is not doing so and has publicly sort of declared from the beginning, from the moment he appointed Jack Smith, that he would not be doing that. And I think that it's an interesting tension there where he's essentially saying, look, I am supervising him, but I'm not, right? And I think that's part of why there's any discussion here or anything to discuss.
But he has the discretion to make that choice.
That's right. But it's an interesting thing, right? It's like you're making the discretion, so do you still have the authority? I mean, I think the answer is yes, you do, right? If my wife lets our teenager drive her car, that doesn't mean she doesn't have the authority to say no. It just means that she chooses to let her drive the car wherever she wants. But I think that's essentially the argument that Trump's team is making. Do I think this is worth 2 days of argument and amici and all of this? Probably not. But it's interesting. And I think that, there clearly Trump's team is trying to egg Cannon into making this, putting herself out there here. Morrison v. Olson was very unpopular in the Federalist Society crowd. A lot of my friends that are in that vein were always talking about it for many years and how wrong it was, and Scalia was right. So I think they're trying to egg her into doing that because I think it would have some maybe political value for Trump in addition to just mucking up this particular case or creating a hurdle for Smith. It would also just be a talking point that he could use to say that there's some illegal prosecutor after him.
Yeah, though, of course, let's just not forget that would also make David Weiss, the special counsel who investigated Hunter Biden, illegal and unconstitutional. It would also make Robert Hur, the special counsel who investigated President Joe Biden, illegal and unconstitutional. I'll just note that in these earlier cases that challenged Mueller, one of the things that the judges who upheld it, particularly Judge Friedrich, the one in the case with the Russian defendants, spent a lot of time not only on the supervisory issue, but on the removal issue. That because what they were arguing is, the special counsel can also only be removed for cause. So this really effectively makes him almost completely independent, because unless he's like derelict or incapacitated, there's nothing that the attorney general can do. And the judge said, actually, that's not true. The attorney general can actually rescind the special counsel regulations and therefore remove the basis on which the special counsel has any legal authority to begin with. And it's really interesting because you'll recall during during the early Trump years that there was a big question, can the president fire Mueller? And, there was a lot of debate over whether he could, but I think what was ultimately settled on was he can theoretically, at the very least, order his attorney general to rescind the regulations, which would effectively terminate the special counsel.
Yeah, I think that may ultimately be decisive in front of Judge Gannon as well. At the end of the day, the special counsel is a creature of these regulations, which are created by the attorney general ultimately, and they can be changed or rescinded at any time by the attorney general. So I think that may be enough. And yes, it's a practical matter. Will the attorney general do that? No. But does the attorney general have the authority to do so? I think the answer is clearly yes.
And I mean, just to kind of tie it up for our listeners and viewers, it really, this ongoing debate, whether it was, under the former independent counsel statute or under the current special counsel regulations, is this inherent tension in our constitutional framework, which gives the president the authority to enforce the laws. And the question is, well, what if the president is the wrongdoer? How does that work? And it is a fundamental tension that I think it becomes really, really legally and constitutionally tricky to resolve. And all of these are efforts to try to find a way to ensure that the sitting president can't be above the law without violating the design of the Constitution as it's written.
Yeah, I actually think the special counsel regulations are a very clever way of essentially ensuring that if some shenanigans are going to go on to protect the president, everyone's going to know about it. So if the attorney general is going to quash the authority of the special counsel to do anything, essentially neuter the special counsel, at the very least, it's going to become something that lawmakers are going to know about, and then presumably, the rest of the country will as well if something really awful is going on.
Right, because the regulations require him to report that to Congress.
Right, report anytime he overturns the special counsel. Whenever they disagree, the attorney general has to report it. So that's essentially the mechanism. The mechanism isn't that the special counsel can do whatever he or she wants. The mechanism is essentially sunlight.
Correct.
And rescinding the regulations would do the same thing. If the attorney general suddenly rescinds the regulations, gets rid of the special counsel, then everyone knows about it.
And we saw under the Trump administration with Bill Barr why that's important, right? Because Bill Barr really could kind of bury things without anyone knowing. I mean, he tried to do that with the whistleblower complaint about the perfect phone call with Ukraine. It was the head of the Office of Legal Counsel, Steve Engel, our classmate, who wrote an opinion saying that, it was basically kind of legal sophistry, which claimed that this did not have to follow the letter of the law, this complaint, and reach Congress. So they kind of buried it. I think there was also, analysis of whether the request of, what that Trump was making to Zelensky violated any kind of criminal laws and that kind of stuff. We never know what happened to that. In other words, if it's left only to the attorney general, there is no obligation to make any of that transparent. And you can get people, like if you get people like Jeffrey Clark to, write some legally justify something never seeing the light of day or something never being prosecuted, no one ever knows.
That's right. And just to be clear, the regulations have loopholes effectively as well. I mean, one thing we saw Bill Barr do is try to essentially sweet talk or persuade U.S. attorneys to do whatever he wanted them to do, sometimes successfully. In the case of, for example, not just Yalu, but the subsequent U.S. attorney
and Berman in New York.
And then I was just going to say, but then tried to with Berman and fail. I mean, Berman essentially withdrew before going along with that. But nonetheless, if you have an attorney general who appoints a special counsel, who essentially the attorney general can influence, that's a way around the regulations. But realistically, that's the sort of thing you can't easily overcome in our constitutional system, where you can't have some creature, that's off on their own, that's not really appointed by anybody, not accountable to anyone, just sort of off doing their own thing.
It's really interesting because it's like, it's easier to police a politically motivated prosecution because it has to kind of be in the light of day. It's much harder to police a declination to prosecute.
Indeed. Jack Smith filed a motion to modify the conditions of release for Trump. It's essentially a form of a gag order, basically saying Trump is a criminal defendant. He's out on bond, essentially, and he has certain conditions of release. Some of them are standard. Cannot use illegal controlled substances. Some of them are, maybe not as standard. And essentially, they wanted to modify the conditions of release. And really, what Jack Smith's team was complaining about was false statements that Trump made about the FBI. He essentially claimed that Trump was saying that the FBI, quote, was authorized to shoot me, unquote. And he knew, in this motion, as Jack Smith points out, that actually what Trump was referring to, he knew that these are just standard, a standard policy that you would undertake and the agents would be informed of before there was any search warrant. And in fact, there was great care taken before the Mar-a-Lago search warrant to ensure that Trump's family wasn't there, to coordinate with his attorneys and staff and so forth, and really to make sure that this was as seamless and unobtrusive as possible. But instead, Trump is lying, and they're basically saying that this is putting the lives of law enforcement at risk, and therefore the judge needs to curtail his speech.
Yeah, and I just want to emphasize that it's not only standard language that's included in any operations plan when you do a search or arrest or something, but the language that they pointed to that they claim was like authorizing an assassination is actually an enumeration of all the ways in which agents are obligated to limit the use of force. In other words, law enforcement actually has a lot of latitude to, use force when they have a reasonable belief that, there is danger. And this is all in the wake of, prior incidents with the FBI that this evolved to make sure that agents are aware of the limits on that. I just want to make sure that's clear.
Yeah, I know. I think that's right. And I mean, I don't think that there's, any question whatsoever that Trump was lying. There's no question whatsoever that the agents were not authorized to kill Trump, that this was not some big setup to try to assassinate him or whatever Trump is saying. But I do think, and maybe I'll get some angry YouTube comments on this one, I think it's at best a close call, but it's certainly questionable whether or not these statements, which are false, are sufficient to warrant modification of the conditions of release. I do think that, Cannon has taken a very hostile view to them, and it's not, I would say her view on it is not mine. But I think, given how prior restraints in speech are so disfavored under our laws, that really, judges telling people not to talk in advance is usually something that's disfavored. I think that there need to be some more particularity regarding the danger that it poses, because Trump's not directing this to specific FBI agents in general. I mean, Trump says all sorts of false things about the FBI and wants to dismantle the FBI and claims all sorts of awful things about law enforcement. He's been doing that since 2016, 2017. But I'm not sure that this is itself a threat to specific FBI agents.
I don't disagree with you. I just have to wonder whether it's really Jack Smith's intention to be successful in this. One of the things that I have written about is the information asymmetry that exists with the Department of Justice and Trump, because the Department of Justice only speaks through its filings, whereas Trump can speak whenever he wants. So he can take advantage of these information vacuums to put his narrative out there. And so whether or not Jack Smith is successful, what he has successfully done is gotten a competing narrative at least in circulation, one that is not only going to be heard in a courtroom, but is at least like we're talking about it now. So in other words, it at least puts some speed bumps, I think, on Trump kind of having that, first mover advantage and this vacuum in which to shape public perception. And I think I would just argue that maybe he's just like, look, like, homie, don't play. I am going to call you out, and whatever, I might lose the motion, but at least I have forced you to engage with, my version of this. That's what I think is going on.
I think that's right. I think that's exactly right. And I think in a different form, in a different context, this might have landed very differently in a judge. In other words, it is in fact the case. Hello, Pancake. If you're not watching on YouTube, Pancake is making one of his very frequent guest appearances. It is often the case that the defense has the advantage of saying whatever the heck they want. And the prosecution gets very frustrated by that because they have to be careful because their statements can potentially impact the rights of the defendant and potentially result in the prosecution being overturned. So they have to be more careful. But that's part of our system, and partly, the prosecution has the advantage of putting out a press release and getting everyone to pay attention to it using a big megaphone. Usually the megaphone is in the hands of the prosecution, not in the defense. This is obviously an unusual case. Realistically, though, if a defendant is saying things that are untrue or wrongful, the prosecution's recourse is to put it in front of the judge, and the judge gets upset about it and strongly suggests that the defendant it's a bad idea to be saying these things. And the defendant knows that judge is going to be sentencing her or him in the future, potentially, and or at least making a lot of decisions regarding the trial. And they think, this is a bad idea. Maybe I shouldn't upset Judge so-and-so with my questionable comments. And then they refrain. But these usual, ways in which we operate, which some people, talk about this, I remember during the Trump presidency, as norms versus laws. This is how the system usually works. It totally breaks down when the defendant has a giant megaphone, much bigger than any special counsel, and when the judge is very favorably inclined towards the defendant in this case, and really has no interest whatsoever in reining in the defendant. And the defendant, in Donald Trump, is not concerned about making sure that he refrains from comments that might, impact Judge Cannon's view of him.
Yeah, which actually brings us to one last very quick note about Cannon and being the judge is sympathetic to him, which is, there was reporting that, there was at least some pressure on her to maybe allow a more experienced judge to take over some of these pretrial motions. And one of them, is it Judge Reinhardt is the original judge that had his, who oversaw the search warrant. I don't know that he would be super excited about this because he dealt with a lot of the fallout from the false narrative after the search warrant was executed, where the Department of Justice also had to combat a lot of lies that were being told about, planting evidence and et cetera, et cetera. But she has declined to heed the suggestion.
Yeah, it's a rather remarkable story. This was in the New York Times. The two judges approached Judge Cannon at the time the case was assigned. One of them was the chief judge and said, you really should decline this case and let someone else have it. One of the arguments given was that, hey, the Miami courthouse actually has a place where you can view classified material and would be a better essentially venue for this case. The other judge, I think, very explicitly made clear the public concern that, Judge Cannon was perceived as not impartial regarding Trump. And by the way, the chief judge was appointed, I believe, by George W. Bush. She was not a Republican, or Democratic appointed judge. in any event, obviously, Judge Cannon did not heed, as you pointed out, Asha, their advice. And I think it's just a point that we have talked about, you and I, many times over the past months during this case, that once an Article 3 judge is appointed to a case, it's very difficult to get rid of that judge. Almost, I'm going to say it's impossible, but it is very close to impossible. And there's a reason why. I mean, if it was easy, then people like me would do it all the time. Whenever we thought the judge was suboptimal for our client, we would always make some case to get rid of the judge. And here, where you have a judge who's just absolutely hell-bent on, handling this case, it creates a situation where it's very difficult to get her off of it.
Yes. Well, as my civil procedure professor used to say, Article 3, and then you're free.
Yeah, very, very true here.
Speaking of Article 3 and then you're free, we should talk about the Supreme Court.
Indeed. Well, look, this is probably not going to be our last episode in which we discuss the Supreme Court, because there's a number of big decisions that are still in the hopper. But we had, I thought, a doozy that came out in the Rahimi case. This was the Second Amendment case that I think was a bit of an interesting twist, not entirely what people expected.
Yeah. It was really the first case to test a doctrine that was articulated just 2 years ago. And it might be useful for people to just for me to quickly do an overview of sort of the evolution of the Second Amendment cases, because there's not that many. But it's kind of all over the place. And I just think it's important to kind of maybe look at that, because it's really unclear where things go from here. So for a long time, the kind of seminal case that, we were operating under was actually a 1939 case called United States versus Mueller. And this was an appeal of a conviction under the National Firearms Act, where the defendants had transported a sawed-off shotgun in interstate commerce in violation of that act. And what the courts there said was that a sawed-off shotgun did not bear any reasonable relationship to a well-regulated militia, and therefore that prohibition was, and that the criminalizing that was not unconstitutional. And so, we're kind of like going along ho-hum for almost 70 more years with kind of this idea that because the court had, looked at the well-regulated militia piece of it, that maybe what Mueller was really articulating was a collective right, not an individual right. Well, that was dispelled in 2008 in a case called District of Columbia versus Heller. And this was a DC ban on handgun possession and a restriction on keeping lawful weapons like long guns loaded in the home. And this is where Scalia kind of dispenses with this whole collective right idea. And he says there is an inherent individual right to self-defense, and that you have to be able to use weapons for self-defense inside the home, and that the handgun is the, quote, quintessential self-defense weapon. But there's language in this case that he says, nothing in our opinion should be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons or the mentally ill, or laws forbidding the carrying of firearms in sensitive places, et cetera, end quote. So people were like, okay, so that means like outside the home, probably these regulations are fine. So then Justice Thomas says, hold my beer. And in 2022, we have a case called New York State Pistol and Rifle Association versus Bruin. And Thomas writes an opinion, which was challenging a New York law which made it illegal to carry a firearm without a license. Applicants had to show proper cause that they had a special need for self-defense, to carry unrestricted outside the home. And this is where Thomas comes up with this rule that you have to look for a historical analog to the prohibition that existed at the time that the Second Amendment was created. And if you can't find an analog to it, then it is, it's unconstitutional. So I'm going to turn it over to you because that's where we were when we got to Rahimi.
That's right. And I will just say that after Bruin was decided, I think a lot of people thought, boy, gun regulations are just going to be disappearing left and right, because there's a lot that we regulate now that no one could have conceived of at the time that the Constitution was created or the Second Amendment was written, right back in the 1790s. So a lot of people were expecting that the prohibition, like the one in this case, which is essentially whether somebody who is engaged in domestic violence in the past, who was the subject of a domestic violence complaint, could own a firearm. And that's the sort of thing. It's like, well, you're not going to find an analog in, in the 1790s. And so therefore that's it. And by the way, we talked a little bit in our last episode about how Hunter Biden is essentially making a similar argument regarding whether or not someone who is addicted to controlled substances can have their right to possess a firearm taken away.
Yeah, let me just pause right there so that people kind of know where this is, because they're in the same statute. So basically, federal law creates 9 categories of people that are prohibited from possessing firearms. When federally licensed firearms dealers run background checks, what they are doing, like checking for whether somebody fits one of these criteria, in addition to whatever other restrictions maybe that the state might have. And just so people know, this is 18 U.S.C. 922G. It shall be unlawful for any person who has been convicted of any crime punishable by 1 year, so any felony conviction, anyone who is a fugitive from justice, anyone who is an unlawful user of a controlled substance or addicted to a controlled substance, anyone who has been adjudicated as a mental defective or who has been committed to a mental institution, an illegal alien, someone who has been discharged from the armed forces under dishonorable conditions, anyone who has renounced their citizenship, and then the issue here, anyone who is subject to a court order that restrains them from harassing, stalking, or threatening an intimate partner, and includes a finding that that person represents a credible threat to the physical safety of that person.
Right.
So that particular category is the one that's issued at Rahimi.
Exactly. So it's very much in the similar vein, same statute, 922G. And that word, the wording you used from Bruin was an important one, right? Historical analog. And I think a lot of people expected here, given we had Thomas writing for a majority saying you have to have a historical analog from essentially the 1790s, that a whole slew of these prohibitions, not just, let's say, potentially drug users, but also here, people who are subject to a domestic violence order, that those would ultimately fall because you wouldn't find an analog in the 1790s. And then what we got instead, in quite a surprise, is everyone but Justice Thomas in this case, although there's a whole slew of separate opinions, essentially said, and I thought this was there was this wordsmithing, it was like this lawyering. We said in Bruin, historical analog, not historical twin. That's the phrase. So essentially, historical twin is what the Court of Appeals thought that Bruin meant, but twin is not analog. So they don't have to be identical. And essentially what the court did is they said, well, there's a couple of laws that existed back in the 1790s that were similar or analogs. One is something called surety, which is if that you are suspected of future misbehavior, you'd have to post a bond in order to carry a firearm. And the other is what they call going armed laws, with air quotes around going armed. And essentially, if you're going around menacing people with your firearm, which made me think of it's like the Wild West. Like everyone's got their sidearm, and if you're like pulling it out and menacing people on the street, then you could be stripped of your weapon and not be permitted to have the right to carry your weapon. And essentially, what where essentially the Supreme Court came out here was that those are close enough, and so you don't need to have something at the time of the authorship of the Second Amendment that was identical. But if it's kind of close enough and it's in a vague window, then that's good enough to let there be regulation today. And I think one thing they left themselves some wiggle room is that here they noted, and they did, I think, rely upon, that there was a finding in the case here that the defendant was in fact dangerous, leaving open the question that maybe you might have a state in which essentially if there's, let's say, a TRO that's granted against someone in a domestic violence case, that perhaps just automatically they can't possess a firearm, but with no finding actually having been made specifically by the judge, that may not be sufficient.
And this is notable because this was, there were several concurrences, but this was effectively an 8-1 decision with Thomas dissenting. And just in 2 years, you have Thomas going from writing the majority opinion to being the lone dissent, A. And B, I just want to emphasize here, because I'm curious if you think, any of this background made a difference, which is the actual, the policy background here, which, theoretically should not be informing jurisprudence, but really, what was at stake in terms of gun violence and domestic violence. And I'm just reading some of these statistics off of the Brady Center to Prevent Handgun Violence. 60% of mass shooting events between 2014 and 2019 were either domestic violence attacks or perpetrated by those with a history of domestic violence. Black women are twice as likely to be killed by a spouse and 4 times more likely to be killed by a dating partner than white women. Nearly 58% of Asian femicide victims over the age of 18 were killed in intimate partner violence homicides. And 1 in 3 Latinas has experienced domestic violence in their lifetime. So we're talking about really a major factor leading to gun violence in this country. And I just have to wonder how much of that at some level, consciously or unconsciously, in other words, what would have been unleashed if you suddenly had a bunch of people who, are stalking and harassing their intimate partner and have no prohibition on carrying a firearm?
Yeah, no question. And to be clear, I think the Supreme Court majority, 8-1 majority here, reached the right result in allowing that statute to remain on the books. That's for sure. But this is quite a change. And I do think that Justice Thomas is correct, that this is an inconsistency on the part of his colleagues. I alluded to Federalist Society friends I flirt with and have many friends who are Federalist Society folks. And they used to tell me, look, it's almost like a machine. We just look at the text. Then we look at the meaning that the text had back in, 1790 something. And there you go. Like, it all determines, it's like a machine. We don't want to look at results. But here, I think Thomas is correctly essentially pointing out that if you really took Bruin seriously and what was written in Bruin, I don't know if you reach this result. A couple words another phrase that I thought was fascinating from this decision was relevantly similar. Since that is quote unquote relevantly similar to these founding era, prohibitions. Maybe menacing someone with a firearm is different. It's more firearm related, right, than domestic violence. It's not. Is it similar? Sure, but that's not what Bruin said. Relevantly similar. And it's interesting because, of course, a lot of the justices who wrote in support of this decision or the result here are very critical in other contexts of the court trying to grapple with difficult questions and interpret language in a way that is not as strict as Justice Thomas would like. We wanted it to be applied here.
Well, I think it highlights a couple of problems with this idea that you just use history and the text to guide your analysis. Is A, what's the level of abstraction that you're using? I mean, if you really go to the direct analog, I mean, there's what you would essentially get is anything that is protecting at this point people who at that time were unprotected would effectively be invalid. I mean, women had no rights. Presumably they could be shot for whatever, walk into a room and they're having an affair. I mean, technically, those would have been like a justified shooting. Same thing with, Blacks who were considered property. It's sort of like, well, how much? And so if you're going to say, well, we're not taking it that literally, then what's the level of abstraction? How much are you going to zoom out? Is it the general purpose? Is it the actual punishment? And then I think, I read this Politico article that was talking about even Amy Coney Barrett criticizing the historical mode, which is what is the justification that history is the correct mode of interpretation? In other words, you're kind of left with, like, did they say that at the founding? Like, did they say, for all, future generations, you must look to see what we're saying right now? No. I mean, we're kind of, in many ways, it's a choice to use that as the lens that you're going to interpret the Constitution, and you have to have a justification for that. What is that?
Well, I will say the impact of it, the ultimate effect, is that it makes the Constitution very ill-suited to any, to a lot of modern purposes, right? I mean, in other words, the people, the people who ultimately created the Constitution back in the 18th century could not have conceived of an air force or rocket ships. They were not conceiving of interstate highways in the way that we are now. Pandemics in quite the same fashion that we do now. All sorts of circumstances and things that we are part of our kind of everyday understanding. Internet, cryptocurrency. So there's all sorts of things that, if really what it means, we have to have a constitutional amendment every time we've dealt with a new factual situation. That's unworkable, particularly given where our country's at and the hurdles required there. And so if really all we're doing is talking about analogs, right, relevantly similar situations, it sounds a lot like what mainstream jurists have been doing for a long time.
Yeah, and that's what makes Thomas mad.
Yeah, because he's seeing the inconsistency. It's just, his colleagues understood that this was an absurd result. You have a dangerous person who's subject to a court order precisely because they're dangerous. And yes, there was nothing analogous in 1790, whenever the Second Amendment was written, subsequent to the Constitution. But that should not be the entire. That should not end the issue, right? When you have somebody clearly dangerous and clearly should not be.
And it doesn't end the issue, as you said, not even for domestic violence offenders who may have a restraining order without this factual finding, but also for many of these other categories, an honorable discharge from the military. I don't know.
Right. Maybe it was dishonorable because you didn't follow some order or you absconded from your base or whatever.
Yeah. Committed adultery. I mean, whatever.
Right.
Then there was another prohibition that caught my eye.
I mean, an interesting one is aliens. I mean, I prosecuted at the time because we had people who were drug dealers who had firearms, and so if they were not here legally, you could throw in that charge, right, along with the other ones as of unlawful possession of a firearm, in addition to possessing it, in the course of narcotics trafficking.
Well, the prohibition on felons. I mean, that's only, the prohibition is anyone who is convicted of a crime punishable by more than 1 year. What if it's not a crime of violence? What if, look, a lot of these people who are convicted for January 6th may have been convicted for a felony that, I don't know, trespassing or whatever the actual federal offense is that may have constituted a felony, but may not necessarily that particular crime that they charged them with, because maybe it was the easiest one to prove or charge, may not be one that demonstrates a propensity to pose a threat to somebody else.
Martha Stewart, she's a convicted felon. Does Martha Stewart have her right, her individual right to possess a firearm taken away? But, that statute, felon in possession, we've talked previously about how unusual the Hunter case was for a whole variety of reasons. But 922G is a statute I know very well. Most people who've been federal prosecutors know this statute well, because we use that constantly as a way of prosecuting people who are very dangerous gang members, very dangerous violent criminals. I had a case where there's a guy who was convicted of first-degree murder, served his sentence, and then he was out on parole with firearms and ammunition and so forth. So, that's a sort of case where it's like, okay, we're bringing a felon in possession case, but really we're doing this essentially because of inherent dangerousness. But it doesn't have to be that way as a category, right?
Yeah.
So if you take this stuff seriously, if you take Bruen, or at least seriously as we thought Bruen was prior to this past week, then maybe that entire statute would be limited in a serious way.
And I think it raises a really good question about Hunter Biden's prosecution, because he's a nonviolent drug offender. He has no criminal history. It was just that he was addicted to drugs at the time that he purchased and, possessed it. Is there a historical analog to that? I mean, were people who are, I don't know what people were addicted to then. Were alcoholics prohibited from owning firearms? I mean, actually, when I was reading the Heller case, Scalia knows, because he goes through a whole historical exegesis, that drunks who went around firing their weapons were fined. It wasn't a crime.
They did.
Fines were the way, and he emphasized that. Even these people, they were just fine. They weren't, criminalized. So, it'll be really interesting to see how this all, what a coup for Biden if, the special counsel is unconstitutional and the statute that he was prosecuted with was unconstitutional. It's sort of a be careful what you wish for.
Indeed. He may, potentially an unconstitutional special counsel prosecuting him for an unconstitutional statute if you buy into some of these arguments. So, Asha, before we go, my 16-year-old stepdaughter got her driver's license this past week. I feel like you've already been around the block with this, right? You have already a high school graduate. So what was that like?
It was a really long process. I don't know what your experience was like in Virginia, where I grew up. We took driver's ed in school. And we were able to get our learner's permit at, I believe, 15 and 8 months. And then as long as you completed your driver's ed, and you passed the written test and the driving test, you could literally go get your license the day you turn 16. It is not so in Connecticut. It is like passing some kind of top secret clearance here to get your driver's license. Yeah.
Was there an historical analog to that?
Yeah, I was like, okay, great. When you turn 16, you can get your license and you can start driving, right? Because I'm driving him around all the time. I'm like, this is my ticket to freedom. He's like, no. I was like, well, when can you get your permit? When he turned 16 is when he could get his learner's permit. And at that point, he had to get 40 hours of in-car instruction with me or his dad in the car. And I'm looking up, I'm like, who has the time for this? And then take also driver's ed, which they don't give at school. So I paid $600 out of pocket because it gives you a discount on the insurance. Oh my God, it took so long. And then after you get the license, you cannot have anyone else except, I think, an adult or a licensed driver, your parent in the car with you for like another 8 months.
Wow. Okay, Illinois is not, you can move to Illinois. Maybe
I want to move to Illinois before my daughter has to go through this.
Maybe your kids should move to Illinois. Yeah, no, so Illinois is not that bad. There were a lot of hours that were required. My wife did have the time, put all that time in. And she viewed it exactly the way you did, her ticket to freedom. Because she's the one schlepping around my stepdaughter all the time and all of her friends. And, when you're 16 years old, you don't want to be at home at all. You don't want to have anything to do with your parents. You want to be off doing stuff.
No, and as a parent, you're just a chauffeur. I was like,
right.
Uber driver.
Pretty much. That's my wife's view. And then I'm like, so you're just letting her drive. So she can now drive by herself wherever she wants in Illinois. And I'm like, you're just going to let her just take your car and just drive all over the place? And my wife could not be happier about this development. I'm like, oh my God, what's going to happen to your car? And she's just, thrilled that she's not the one driving.
Yeah, 100%. And what's so funny is that my son, as you mentioned, he just graduated from high school. So it was his senior year. And, especially towards the end, it was a lot of socializing and he was going out. So he would go out at night and I would do what my parents, I would be like, you need to make sure that you're responsible and, do not drink and drive. And at some point he looks at me and he is like, Mom, nobody does that anymore. And I was like, what are you talking? And so I guess basically it's now, I don't know, his claim was I don't know if it's they're just completely socialized into this norm now in a way that maybe in the 80s we weren't or something, but
okay.
He just looked at me like I was crazy. Who does that?
There's a lot of DUI prosecutions in my state. So
okay, I don't know. But he was claiming that was not a worry that I should have.
Youngsters do all sorts of stuff. They have their edibles or whatever. I wouldn't want anyone.
Yeah, maybe now, maybe edibles and marijuana is the new alcohol. Maybe that's what he's he was like, nobody drinks anymore or something.
If it was my car, I would not want anyone driving it.
No.
They're having used any of those things.
I just do the scared straight talk. I'm like, because he has a ROTC scholarship and I'm just like, this is the rest of your life. You want to F it up? It's your choice. But you can toss all of that out the window and you can toss your future security clearances out the window. And I basically so I think I've now psyoped him to make sure that he doesn't do any of that.
Wow. All right. So it works.
It works for him because I think that he wants a career doing things like that, You
are a lucky mom.
MSW Media.